As you have noticed, good morning, everyone. As you must have noticed, we have decided deliberately to give you a feeling of how it feels to be in the Middle East. We are very proud to be those who do not start in time. So we apologize for not conveying this information for you. We just wanted you to feel authentic, and I borrow here from Josh, our friend. So I deeply apologize for the delay. There was a problem with the transportation company. These things happen, and I'm really sorry for that. We'll see how we'll carry on as usual, as we planned, and later on during the day we'll see how to, if there's any need to reschedule panels accordingly to accommodate the delay. So I ask you to relax in your seat, have a deep breath, and let's start and kick off this conference. So good morning again. I want to start with a story about how all this happened. In 2013, I met my colleague Ariel Flavian for the first time through a common friend who was my teaching assistant, who introduced Ariel to me. He was just about to finish his PhD from Brunel on class actions, and then he came to me with a very strange idea of organizing a conference on class actions. Now, I had nothing to do with class actions. It wasn't in my research fields. I had nothing to do with that. But I was clever enough to say to him that I agree, and I knew that it's going to fail. Nothing would come out of this. Who would come to Haifa? Who would come to Israel to discuss class actions? We did not invent that. We have this quite recently. So I said, well, fine, yeah, let's give it a go. And to my surprise, it was really successful. We managed to organize a really very good conference, and it worked out. And with success comes appetite. Once the conference was done, you know, I was very exhausted and I couldn't think of another conference, but Ariel was very enthusiastic. So he came to me again and said, well, you know, let's do it again. I said, no way, absolutely not. I've had enough of that. Now Ariel insisted, and he insisted again, and in the end I had to give up, and we did it again. But when we did it again on the second time, it was 3 times as big, and I told Ariel, never again. That's it. I'm fed up with that. And I knew in my heart that that was really the end of the story. He was kind enough to give me a few months to prepare for the idea of having a third conference, and he came back again to me. Anyone who knows Ariel knows that he doesn't give up at all, and he has very high standards and keeps pushing all of us to do whatever he likes us to do. And in the end, he came to me, again, the same story. He insists, I reject, he insists, I reject. In the end, I give up, and I agree with him, and we do it again. Here we are. So that's how all this sort of 3 conferences came about, and I plan by the end of this conference to tell Ariel never again, and I guess that he will tell me no way, and we'll do it probably a 4th time. Ariel, thank you very much for the exceptional work you've done. You've been really the real spirit behind this conference. You are a treasure for the law faculty. We appreciate this. You're a true friend, and we really appreciate all the hard work you've done. I call myself a co-organizer. I call myself a co-organizer because we lawyers, you know, we exaggerate. We tend to exaggerate facts. But the fact is that I was merely his assistant. Now, I know that no one comes to a conference merely to hear the thank you stuff or the welcoming, especially not after 40 minutes of delay. So I will promise to be as short as I reasonably can, but we in the Middle East have this habit of focusing on greetings and on honor and respecting people. So I have really to give all our supporters what is due to them. Many people have worked very hard to put all the bits and pieces together, and I would be remiss if I did not give them what they really deserve in terms of thanks. So I first want to thank all our distinguished speakers who came from abroad to join us and to contribute to the success of this conference. We don't take this for granted. We appreciate a lot your effort and the thought that you put in preparing your presentations, and we look forward to having really a terrific 2 days of stimulating discussions and engaging exchange of ideas. I also want to thank the audience, all those who registered to this conference. We have about 60 speakers and around 60 registrants who come also, most of which come from abroad. So we really appreciate that. We welcome you here in Haifa. Ahlan wa sahlan bruchim habaim. As I noted, also, putting this conference together requires a lot of resources and a lot of manpower, a lot of goodwill and hard work. So I would like to mention that there are, in the organization of this conference, 41 institutions have joined hand in hand to make this a success. And I apologize in advance for the length, but I think we need to acknowledge their help, to acknowledge their support, and I would like to read the names of the institutions and the law firms that have sponsored and supported us in this conference. So we have 14 universities from 11 countries, and I apologize for the misspelling. University Federal de Rio Grande do Sul from Brazil, Paris Sud University from France, Constance University from Germany, City University from Hong Kong, City University of Hong Kong, European Institute in Italy, Tilburg and Radboud universities from the Netherlands, University of Lisbon from Portugal, University of Girona from Spain, and universities of San Francisco and Texas from the US, and UC Hastings College of Law, in addition to Brunel University from the UK. So thank you all for the academic partnership and for the help you've given to us and for sending delegations to this conference. Now I want to thank the sponsors, those who really put their good money on this conference with the hope that we will produce high-quality conference. So I will read them alphabetically. From Australia, we have IMF Bentham, litigation funding. From Belgium, Cartel, damage claims, optimizing compensation. From Germany, Klaus Rotter law firm. From the UK, we have Housefeld, Mishkondiria, Global Legal Group, Oxera, Woodsford. From the US, we have Baker Hosteller, Berger Montage, Cohen Milstein, Joseph Savari, Kellogg Hansen, Leif Cabraser, Heyman and Bernstein, Milberg, Tadler, Phillips and Grossman, Morgan & Morgan, and Pomeranz. In terms of litigation-related services, we have Engine Group, Econ One Research, and Meta-E Discovery. Thank you all, and I want to thank also our local sponsors from Israel. And I'm reading this alphabetically. Agmon, Rosenberg, Hakohen, Vishut and Co., Arnon, Ben Ari, Fish Saban, Fischer Bachar Chen, Weil Orion, Herzog Fox Niemann, Perelman, and Shim Friedman, S. Friedman. Thank you all, and please join me in appreciating their help. And now, I want, there's a lot of logistics complicated here, so I think despite what we had in the morning, I've got to still thank all the staff that worked on that. So I would like to thank first our Dean, Professor Oren Gazal Ayal, for the support that he has given us in the planning and the design of this conference. I want to thank Lily, Miri, Sarit, and Yulia Lichinsky for helping us out with all the logistics. I also want to thank our nice conference assistants, Rasha Zu'bi and Mahdi Kabha, very distinguished undergraduates who helped us a lot through this conference. I also want to thank PI Group, who monitored our website and Facebook page, Elad Levy and Avital Levinson. They have all been very patient with us. Ariel and I have one thing in common. We have always unreasonable expectations from everybody, and we impose unreasonable tasks within unreasonable time limits. So they had been very patient with us, and I really appreciate that. And of course, finally, I would also want to thank Rina, Ariel's wife, and Luna, my other and more important half, for giving us the time to work on this conference and plan, and also do the laundry and all the other stuff. Thank you all. We are doing the laundry. Of course. Of course, we were doing the laundry, so that's the support they gave us. They gave us the pleasure of doing the laundry and the dishwashing and all the stuff. I would like to invite our Dean to welcome you as well. Professor Oren Ghazal Ayal. He's really a leading and world-known scholar in empirical studies, and I'm very happy and honored to invite him to speak. Please, Oren.
Thank you so much, Rabia. Thank you all. It is a pleasure to host the third international conference on mass disputes here in the University of Haifa, Faculty of Law. This conference came for me exactly at the right time. I'm researching in the field of criminal procedure, criminal law, so I know virtually nothing about class action, and apparently I should know much more. Yesterday, and this is a true story, I received a letter from one of my students complaining about the grading in one of the courses. And the letter was signed at the end, sincerely yours, Daniel, in the name of the whole class. So I'll do my best to learn from the sessions how I should respond for such class dispute. We're proud to host in Haifa the leading experts from around the world on the issue of class action. We have guests here from Brazil, France, Germany, Hong Kong, Italy, United States, United Kingdom, Spain, Portugal, Australia, the Netherlands, and some even came all the way from Tel Aviv. Although it now seems more likely I should have said from Leonardo Club downtown. That seems even more complicated than coming from Brazil. Sorry about that. I would like to thank you all for and let you know a bit about the venue, and I'll say it a bit. I'll be a bit shorter than what I planned because of the delay. But this law school, the University of Haifa Faculty of Law, was established in 1991. It already then adopted a very innovative and interdisciplinary set of courses, which was very uncommon in law schools in Israel at the time. Other law schools follow us, and today it's not very uncommon, but we also already lead the way in another way, emphasizing much more in our courses cyber law, law and technology, and issues of new development in law for all students in the bachelor degree. Several courses already from the first year about development and technology in law are taught from the first year for all students. I started studying in this law school in 1992, the second year of the law school. A few years later, Rabia joined the law school as a student, so we are all very much patriotic for these law schools as students and as professors now. Though we are the smallest public law school in Israel, and we keep the numbers small deliberately, in order to have the best professors to student ratio in Israel, and we do. We still host the most important events, legal events in Israel, including the annual meeting of all the high Israeli officials in the judiciary, including the Chief Justice of the Supreme Court, the Minister of Justice, the Attorney General, and all the others, that is held here every year in September. The annual meeting of all the judiciary in Israel, of all the judges in Israel, also is held here in the Faculty of Law in the University of Haifa, and many other events. And of course, now we can mention the relatively new tradition of the biannual conference on class action here in the last 5 years. I want to thank all the organizers. Now, I won't repeat all the names that Rabia already mentioned. Time is running, and I think it's you had enough with congratulations and thanks. But I cannot avoid mentioning three important people. First of all, Rabia, my dear colleague, and Ariel, who really envisioned this conference and made it happen day and night, really day and night, including Fridays and Saturdays, all the time working on it amazingly to pull it over. And it's really the work of these two people. And last but not least, Lily and all the administration of the university, who are sort of a one-man show for administrating this international and very complicated logistic event. So without the wonderful dedication, work of these three people, this conference, of course, would have never succeeded. I wish you all a fruitful and enjoyable conference. Thank you so much.
Okay, thank you very much, Oren. I would like to invite a senior partner of ours, Grant Howells, to say a few words. Grant is a veteran of this conference. He's the Dean of City University of Hong Kong. He's been with us for 2 conferences, and he has devoted a lot of time in helping us planning and thinking about the conference. He has been always available all the time, despite the difference in time zone, to give us, share us his wisdom, his advice, and his consultation. So thank you very much, Grant. I would like to ask you to come forward.
Well, thank you, Rabia, for those kind words. I don't think I personally have done too much, but I know City University has been very active, and my colleagues, Matteo and Andre, who were previously at City University, worked very closely in organising the conferences with you, and it's great for City University to be involved with this conference and with Haifa University. And indeed, our cooperation continues in between conferences, because very kindly yourself and Ariel have come to City U and taught class action law to our students in Hong Kong. So that's a great way for us to keep the momentum up in between these events. I thought that I would just spend a few words telling you about the position of class actions in Asia. And I think one of the ambitions of this conference in the future is to try to broaden its scope. And I know we've got many people from South America here this time, so that's great to have that. And I hope next time we can encourage people from Asia to attend. Actually, in the common law countries of Asia, that's Hong Kong, Singapore, and Malaysia, I think you find that there's not a lot of action in the class action field. The Hong Kong Law Reform Commission did propose that there would be a class action procedure, and suggested that it should first start in the field of consumer protection law, which happens to be my own field of expertise. But sadly, that hasn't been acted upon, and that's quite a common trend in Hong Kong. In many areas of law, we have very important proposals for reform from the Law Reform Commission, but the parliamentary system, which is quite political and sometimes filibustered in Hong Kong, stops action taking place. But actually, I just took a tour around Asia and saw that actually class actions are becoming increasingly common. In China, there's at least 4 ways in which you can have class actions. There's a joint litigation procedure, there's representative litigation procedure, and there's 2 models of that, one for where there's more than 10 partners and one for less. And also, perhaps most importantly, public interest litigation, which is very strong in the field of environmental law and consumer protection law. I would add a caveat that actually some law firms do run into trouble with the authorities sometimes when taking class actions, because they're seen to be disturbing social cohesion. So I think if I was a lawyer in China, I'd be very careful about just how I use those powers. But there's a certain tension there that the government in China is trying to actually make people accountable for environmental and consumer problems, and class actions is certainly on the agenda there. Again, in Japan, you see there's a special procedure where qualified consumer organizations can take actions. Mainly that's for injunctions, but there's been about over 50 of those actions brought by consumer organizations. But especially qualified consumer organizations can bring actions for damages, and although those numbers are in single figures, they're still possible. Again, in Korea, you see there's also a class action procedure, initially established in the area of securities law, but now taking place in the area of consumer protection, following a test case involving BMW cars that caught fire. In Thailand, again, since 2015, there's a class action procedure where class actions will be brought under various laws, including not only contracts and torts, but consumer protection law. And in Vietnam, there's also a procedure where the biggest case to date has been about the iPhones and planned obsolescence of the iPhone. And in India, again, there's special procedures available in several sectors for class actions, and these are developing all the time. And in the consumer field, my area, there's a way in which consumer organizations can bring cases, and the biggest test case today has actually been against a noodle manufacturer, but apparently there's test litigation ongoing involving Uber. So I just did that tour to say to you that actually class actions is a phenomenon which is on the agenda in Asia. It could actually do with its profile being raised in some countries, including the country where I reside at the moment, Hong Kong. But I think events like this are important for us to re-energize ourselves and reconnect and discover what's happening around the globe. I know that in several European countries there's developments afoot, and of course America is always somewhere we look very closely to for inspiration in this area, although at the last meeting I gained the impression that there was a decline in class action litigation in the United States, but it'd be interesting to see if that's been maintained or turned around. So I will be brief because we're short of time, but I wanted to say that Hong Kong City University is very pleased to be associated with this conference, and we see that teaching civil procedure is very important. Actually, at the moment, civil procedure is mandatory in the undergraduate curriculum in Hong Kong, and we also teach it again in our professional training course. So civil procedure is important for us, and class actions is an issue that's on the agenda, not only in Hong Kong, but also across the Asia region. Thank you.
Thank you very much, Geraint. I would like to invite Khali Ben Ari. Khali is the head of Ben Ari Fish Saban, leading and one of the biggest law firms in Haifa, along with Shin Friedman, represented by Itamar Anabi, our friend and colleague. Khali was also the head of the Israeli Bar Committee in Haifa. She is a dear friend of the faculty. Her office supports the faculty on a number of projects, so we are quite really very happy and honored to have her here with us. Please, Khali.
Thank you. Good morning, all of you. We're all honored and excited to open the third Haifa International Class Action Conference. It began in November 2015, sponsored by 5 local law offices and 1 Amuta, non-for-profit organization. 2 years ago, it has expanded by a welcome addition of 2 new academic partners from Italy and Hong Kong, and 12 new sponsors, half of them from the USA and half of them from Israel. Now you can witness an unbelievable, dramatic growth. 41 partners, 14 universities, and 27 sponsors from 12 countries. Really amazing. There are more than 60 speakers, including 4 judges from US, England, Holland, and Israel. It is not just a tradition, it is an expanding tradition at an extraordinary rate. This great achievement could not have happened without 2 special and really crazy guys, colleagues, that have initiated the idea of a conference, dreamed and made it happen. Dr. Rabia Assi, that all of you already know, a faculty member of the law school here at the Haifa University, and my dear friend and colleague, Dr. Ariel Flabian, a leading practicing lawyer and partner in the first law office in Israel, Herzog Fuchs Neiman. And I don't know if you know, but Ariel has published a few landmark articles on our subject. On behalf of the sponsored and the academic partners, I would like to thank you both, Rabia and Ariel, and the Dean of the Faculty of Law and his staff for your endless efforts to making this conference a reality. The Class Action Institution has a great social role. Therefore, from my point of view, the one particular topic that will be discussed here tomorrow morning, listen, 1 hour less to sleep this night, is highly, the topic is human rights class action, is highly interesting, and no doubt the lectures will stimulate our minds and will contribute a new way of thinking. Unfortunately, human rights become much more apparent in times where even in established democracies, it can't be taken for granted. I sincerely hope that all participants enjoy the presentations and take home new ideas, more creative thoughts, and many unsolved questions, topic to think about for the next conference. Thank you.
Thank you very much, Khali. Now I want to invite another senior partner of ours, Eric Kramer. Now, I have to say that I had a difficulty with Eric yesterday because to introduce somebody, you've got to read his bio and then try to just put some highlights. So I read the 10 pages of his bio and I started highlighting. I ended up highlighting the 10 pages. So I just didn't know what to do. So I had I didn't have any other choice but to highlight really very random facts about Eric, and I apologize in advance for being incomplete. So Eric is firm chairman and co-chair of Berger Montage Antitrust Department. He has a national practice in the field of complex litigation, primarily in the area of antitrust class actions. He is currently co-lead counsel in multiple antitrust class action across the country across the US in a variety of industries, and is responsible for winning numerous settlements for his clients totaling well over $2 billion. Now that's amazing bit, listen carefully. In 2018, he was named Philadelphia Antitrust Lawyer of the Year by Best Lawyers, and in 2017, he won the American Antitrust Institute's Enforcement Award for Outstanding Antitrust Litigation Achievement in Private Law Practice. He has also been identified as top-tier antitrust lawyer by Chambers and Partners in Pennsylvania and nationally. He has been highlighted annually since 2011 by the Legal 500 as one of the country's, one of the US top lawyers in the field of complex antitrust litigation. And he was repeatedly deemed as one of the best lawyers in America, including in 2018. In 2014 and in 2018, Eric was selected by Philadelphia Magazine as one of the top 100 lawyers in Philadelphia. So I'm very honored to have Eric with us here. I would like to ask you to come forward and give your blessing for the conference.
Thank you. Thank you, Rabbi and Ariel. I'm really honored to be participating in this conference and to have been chosen to help organize the conference. When Rabbi asked me about my bio, and he was joking with me about what facts he should say about me, I just said, say that I'm the father of Ethan and Hannah, and stop there. So I wanted to answer very briefly the question that's up on the screen: why are we here? We live in a world that in some ways is coming apart at the seams. Democratically elected governments are losing credibility. Wealth and power are becoming more and more concentrated in the hands of a few. Multinational companies control our information and decide what we wear, buy, eat, watch, and read. And in that context, it is all the more important that injured consumers and citizens and workers and property owners and shareholders have an effective means to obtain collective redress through the courts. It is critical that people and companies injured by anti-competitive conduct, fraud, pollution, and other forms of misconduct have a means to obtain relief through civil actions, through the courts. The alternative to civil relief, at best, is to accept injustice, and at worst, to foment civil discontent and fractured societies. People need effective civil outlets to right mass wrongs and obtain collective relief for collective harms. So making class actions great again across the world has never been more important. And if we are going to achieve that goal, what we need is more conversation among the leading practitioners, academics, and judges from around the world. Let's figure out what works, what doesn't work, and what can be improved. Let's discuss the underlying values and principles behind the various international systems of collective redress and see whether the practices and procedures we have in place are designed to effectuate those principles. Let's fix what's broken and maintain and support and promote what works. So a conference like this has never been more important and more timely. And this particular event has come to be one of the premier conferences in the world on collective actions. We have leading academics and practitioners. We have lawyers for claimants and lawyers for defendants. We have economists. We have claims administrators and claims aggregators. We have leading jurists from around the world. So I'm proud to have helped organize this event and happy to have made my second journey to Haifa in 3 years. So I look forward to the lively and challenging discussions over the next 2 days. Thanks very much.
Hello, thank you very much, Eric. I would like now to invite Ingrid Gaba, another partner of ours in the organization of this conference. So Ingrid has conducted strategic public and private law litigation and has been a law lecturer over the past 20 years. She brought test cases and group actions at the Legal Aid Commission in New South Wales, in Australia, where she formerly practiced before she moved to England in 2003. Ingrid currently acts for communities who are affected by large-scale corporate violations, including in the fields of labor, textile, supply chain, mining, and agribusiness operations. She has a special and abiding interest in litigation around climate justice. Alongside her high-level international policy work, her human rights team also runs regular training sessions on access to legal remedies so that frontline organizations can keep abreast of legal developments both at international and domestic levels. Thank you very much, Ingrid, for being with us, and would like to invite you to come forward.
Thanks, Rabi. Thank you, Rabia and Ariel and everybody who has organized this fabulous room of people. Many who I knew years ago when I was working very much in the consumer acquis world and the development of that through the European parliaments, and it's delightful to meet them again today. And I'm not actually speaking now on human rights, I'm doing that tomorrow. There's a plug for my panel, and with Linda and Neil tomorrow morning at 10, please come. I'm actually filling in for the great and esteemed Hans Miklas, Professor Hans Miklas, who I also worked with, and Geraint Howells, who's actually here in himself. I know I don't look like Hans or sound like Hans, but we did work together. And last night I was told to fill in his spot because he's late. So as they do in Eurovision, where you move countries, you know, if you have to, sing another song, and there's a lot of Eurovision people in the room, I'm doing that for Hans. And I'm supposed to be speaking about Which. Now, I did work at Which for a couple of years, and in that time was a very exciting time. It was the development of private enforcement in the competition or antitrust field, and which had been very underdeveloped. So it was there was a lot of talk about bringing group actions for individual consumers who had suffered loss, and we bought this very notorious case in Football Shirt, some of you will be aware of that, which led to a report with the then Minister for Justice being a co-author of the then generic a case for class actions in the UK. I was then working on that for some years, and so there was various discussions about having, you know, opt-out regime in the UK. It started to look like it was going to happen in 2010, post the financial crisis in the finance bill, as it was. There was a little clause there for an opt-out action for individual policyholders and people who'd lost out. That was washed out. So it didn't happen. It came back again with the Consumer Redress Act, and now we're seeing the Schedule 8, a small opt-out regime. So it has taken some years, some 8 years to fulminate, and I'm sure you'll be hearing a lot about that over the conference period, but now we are starting to see actions take place there. In the meantime, I've been busy with the development of the human rights, climate justice area, which is now a very big news, topical news, a lot of things happening in that area. And of course, being with my background in human rights and consumer, there's a lot of comparative law, procedural things, substantive areas where we've been able to adopt, where we've been able to bring those to fruition, where we're under discussion, borrowing from consumer world, environmental world, and vice versa. Data protection, environmental world, there's a huge nexus. So we are now in a time in lawyering, in movement lawyering, where we have to wear our comparative hats, where we have to adopt and look at blueprints that have been created through other types of redress regimes. I think many are nodding their heads now and will agree with that. So I'm looking forward to hearing from everybody in this conference and looking forward to seeing you all tomorrow. Thank you.
Thank you very much, Ingrid. I would like now to invite Professor Claudia Lima from Brazil to also welcome you. Claudia is a full professor of private international law at the Federal University of Rio Grande do Sul in Porto Alegre in Brazil. She's a lawyer and she has a PhD from Heidelberg University in Germany. She has published widely on the areas of conflict of laws, contracts, consumer law issues, and her publication appear in many jurisdictions: Brazil, Argentina, Uruguay, Panama, the US, Germany, etc. Claudia is also heading a Brazilian delegate, which is also present in this conference. We are very happy to have her with us, to have all of them with us, and I would like to welcome her as well.
Thank you very much. Thank you very much. I want just to thanks this very magnificent welcome here in Haifa. Haifa is the city of tolerance, so many religions, so many people together. And as a Brazilian, we value this very much. But I think today in the world, with this fragmentation and these disputes from religion, from political side, from populism, it's very important to bring the people together and to try to build bridges between jurisdiction, between people, and between ideas. So I see this conference as a huge moment to build something new and useful for consumers, for vulnerable people in all the world. So thank you very much, Ariel. Thank you, Rebea, and also Gad and other people and colleagues that helped to put this together. We are very honored to be here and also to help. And okay, let's begin. Thank you.
Last one, I promise. Ariel Flavian has been introduced. He's a senior partner at Herzog Fox Niemann. He holds a PhD from Brunel University on class actions, and he's also an adjunct professor at the University of Haifa in our master's program. Please, Ariel.
Thank you all. I must say I'm very excited, also a bit embarrassed. Thank you, Rabia. I have a very strange role. You have flew here from thousands of miles, and I have to explain to you why did you come here. So you came here because we want to discuss with you some of the recent developments in the area of class action. We have some influence to our event in the growth of global trade. International trade has increased in recent years. Trade actually has become borderless. We have international deliveries coming from different countries. People are buying shares in foreign companies. Services are more global, and knowledge moves fast from one country to the other. Information is sometimes stored in servers out of your jurisdictions, and there are breaches of information data, and we are going to serve the legal consequences of such breach in a panel tomorrow chaired by John Yanchunis, who led the Yahoo very famous case, class action case. But it means as global trade is growing, it means that we will have more international scandals. The role of lawyers is to facilitate global trade. Consumers should know that they have legal redress when and things go wrong. At this moment, there is no legal procedure to deal properly with these cross-border mass dispute situations. We were looking at the developments since the Morrison decision in 2010 in the US, and we saw that US jurisdiction is now closing the doors to outside plaintiffs. Most settlements in the US have a preclusionary clause stating that this settlement is affecting United States consumers only. But we've seen recently some cases which are going around this rule. For example, the Petrobras case, which was settled in 2018 and was led by Jeremy Lieberman, who is the chair of today's second panel. It was, I think, the largest in the US last year, 3 million settlement, and the lawyer who is leading it will be here in our conference. We are very honored. As regards to Europe, we were looking at the development since the Volkswagen case. I think it is a landmark case. It seems that the Dieselgate emphasized the lack of proper redress in European consumers. What happened in this case was that whilst in the US the first settlement was reached in 2006 by San Francisco Judge Breyer, in Europe cases are now in 2019 still in the initial stages. In England, in May 2018, a group litigation order was granted. In Italy, it was approved, but still, and also in Germany, it is in the initial stages, and the damage and concern are very low, much lower than those in the US. Since then, I think European legislators have done a lot to change the law in Europe. We had the committee in 2017, and then which proposed new harmonized system of collective redress for Europe. We have a proposed directive in April 2018. And we have April 2018 recommendation for a new deal for European consumers. This new deal includes a new European representative action. This action will be brought by qualified representative entities, and it provides for cooperation of member states. And this is an inspiration for our second panel with great speakers and representatives from the European consumer organization, BEOC, Augusta. We will have Ingrid, who used to advise for which, the English consumer organization, and we will hear how things have been done in Brazil by the Brazilian head, Mr. Carvalho. The New Deal for consumers in Europe also provides for strengthening existing tools for consumer alternative dispute resolution and online dispute resolution. This has affected our last panel of today, chaired by Kobi Sharvit, with Francis McGovern and other specialists, and two of our friends from the Netherlands, and Matea, who will teach us how to mediate and how to take things out of court. We will also have a keynote speech by Professor Issakarov tomorrow about out of court or different ways of collective redress. It is also a common practice now in Europe, whereas there are no contingency fees almost, that funders are leading collective redress. The European New Deal requires funding to be transparent. And Europe also requires some European supervision over third-party funding. We will discuss this development with two leading global funders, Bentham and Woodsford, and Anjan, who's moderating funding of litigation, and the question of ethics it raises, which will be discussed by Joshua Davis, Professor Joshua Davis. We were also impressed by some of the national recent developments in the area of class action. Just to give you a few examples, last week the Dutch Senate approved a new collective redress for the Netherlands. It was not enacted yet, but the first stage has passed. This will be an opt-out system for Dutch consumers and opt-in for foreign plaintiffs. We were also very impressed with some of the progress which have been done since the Consumer Rights Bill of 2015 in England. We were fascinated by the MasterCard case, where a collective redress indeed was denied in England. One of the reasons that this collective action was denied was that the plaintiff did not succeed to prove that damages were passed to the consumer, what is known as the passing on defense. This decision brought us to the conclusion that we should have a panel with great economic experts from different jurisdictions to see how damages should be calculated in class actions. We will discuss new trend in global competition class action in a panel headed by our friend Eric Remer. We will have a wonderful keynote speech by Professor Kofi, who wrote a special article for our event. It is published on the event website, and it will deal with how settlements can be enforced in different jurisdictions. We were also looking at some of the developments in the US, the Tyson Foods, for example, the case where the use of statistics and sampling in class action was approved. This use of sampling is also known in Israel, and we have Itamar Anabi, who is moderating this panel, and he has a lot of experience in sampling of class action. But I will make my speech a lot shorter than I intended, but I would not like to skip on the human rights panel. This panel reminds us the times that lawyers were regarded as knights. It is a wonderful panel. Class action was once used to protect the ethnic minority, weak classes of people, and even Holocaust survivors. It reminds us how good class action may be for the society, and what great job lawyers can do to promote the society well-being. So, we're here to discuss cross-border trade, to learn from different jurisdictions. I think we have the best team for these discussions. Lawyers from different jurisdictions, professors from about 14 different universities, and even judges from about 4 different jurisdictions. It's a great team, and I thank you all for joining us. The list doesn't end, huh? Okay, my final comment is, so we are also here to have fruitful discussion, to meet great people from many jurisdictions, and also to have pleasant time together. I wish you a good and successful conference. Thank you.
thank you for your patience with us. Now we get to business, and I would like to move straight forward to panel number 1 with Gil Orion and all the other guests. So please come forward. Stay here, please. We are moving immediately straight to the panel.
Yes.
We're not supposed to drink from the bottle like this. Good. Thank you.
This is the folder with your presentation, okay? Yep. This is yours? You are now?
I don't know. I want to go first.
Excuse me?
Because Dean Howells basically gave me my opening line. No, I don't know. I hope so.
When is your presentation?
I'm not sure it's this panel, but I'm not sure about it. Can I take that?
Just remember the date, okay? Minimize here.
I'm happy to start. Whenever I get a chance.
No, Alberto. My name is Gil.
You get the red seat.
Great, no problem.
Good morning, everybody. It is my pleasure to open the panel on global developments in class and collective redress. My name is Gil Orion. I am the head of the litigation department at Fisher Bachar Chen Well Orion & Co. in Tel Aviv. It is so encouraging to see so many plaintiffs' attorneys and plaintiffs' advocates in the audience. You know, you are the main source of work for us on the defendant side. Allow me to start by saying a few words about recent developments in the Israeli market in class actions. Class actions in Israel are flourishing. The number of cases is growing rapidly, and the complexity of the cases is increasing significantly. We are dealing with complex procedural matters such as service of process, jurisdiction, limitation periods, pass-on defenses, as well as with quantification issues involving deep legal and economic analysis. There is an exponential increase in claims against multinational companies in areas such as antitrust, securities regulation, privacy and data protection, consumer protection matters, and so on. you thought we are a startup nation, so I would like to tell you the truth. We are a class action nation. These developments are deeply influenced by case law and academic research, both in the US and in Europe. It is perfect timing to introduce now our first panelist, Professor Richard Marcus. Rick holds the Coyle Chair in Litigation at UC Hastings in San Francisco. He's lead author of leading case books in the US on complex litigation and civil procedure. He has served since 1996 as associate reporter of the US Judicial Conference Advisory Committee on Civil Rules and had primary responsibility for drafting proposed change to Rule 23, the US class action rule. Rick is going to talk about the evolution of Rule 23 and class actions in the US. Please, Rick.
Thank you.
Sure, my pleasure.
Thank you very much to the organizers. I hope you can hear me out there. Good. Okay. I'm here partly to give a response to, okay. I'm not sure I need that, but all right. Good. Okay. I'm here partly to give a reaction to a question that Dean Howells raised in the introductory or welcoming panel, because I'm here to talk about the big bad wolf. That is US class actions. And I think in many parts of the world, those are regarded as equally welcome as the big bad wolf. Well, our big bad wolf has been around for a bit over 50 years. It was invented, as Jack Coffey has pointed out, by the 1966 amendment to our class action rule. And the really interesting thing about what has happened during the last 50 years, to my mind, is the people who invented it didn't see where the big pressure points would turn out to be. They didn't focus on settlement of class actions. Only years later, 15 years ago, did our rule come to look at how settlement class actions are handled. And that is where the action has been for a long time. So what went into effect in the US in December of last year was a further effort to deal with how class actions are settled. The other big thing that happened was something that the last panel tomorrow that I'm going to be on it has been addressing more and more frequently, and that is class certification. Not clear that the people who wrote our big bad wolf rule thought too much about how much effort that would involve. They said it should be done right up front before anything else. That has turned out not to be true, and indeed most of the litigation activity by American lawyers in American class actions happens before class certification, often in conjunction with a proposed settlement, and that's where our action has turned out to be. I'm not saying that's in the future of any other country. Partly that's a consequence of our opt-out rather than opt-in system. But what we have done in our country is to bolster guidance for judges in handling the question whether they should approve proposed settlements. Now, I think later today you'll be hearing from Judge Dow, my boss in this project, concerning the role of the judge. The role of the judge is to do a lot of work nowadays that maybe some judges in the past in our country didn't do. So that's what's happening with our big bad wolf. And I want to switch gears a little bit because there was also some mention in the first panel of the VW diesel litigation in the US, which is housed, so to speak, right up the street from where my office is, a block away where the federal court in San Francisco is located. On Tuesday, the day before yesterday, I was sitting in Kansas City next to Elizabeth Cabraser, as in Leif Cabraser, one of the sponsors of this program, who is also the lead counsel for the plaintiffs in that case. And as she confirmed, as I already knew from reading about it, a lot of customers in Germany and elsewhere in the EU who feel that they were also misled by VW are wondering why the Americans are doing so well while the people in Germany and elsewhere in the EU are not getting anything like the relief. Well, one reason perhaps is they're not represented by Elizabeth Cabraser, but another reason is our new big bad wolf, which is multi-district litigation called MDL litigation. In the US federal courts right now, if you look at civil cases pending before the US federal courts, around 40% are subject to an MDL transfer order. So there's another big bad wolf out there, which is the subject of proposals before Judge Dow and our committee to come up with some rules for running those. I am not in any position to tell you whether that will happen. I can tell you that that is a major concern in the US, and it might indeed, from my understanding of it, resemble what happened with Deutsche Telekom when the German courts were overwhelmed by individual actions. That's where our MDL practice came from, roughly the same time, 50 years ago. And it has since, in the last 15 years, become, for many, the biggest bad wolf out there. So maybe you could do better than we have done, but maybe you do need a wolf outside the door to avoid having your customers fleeced. Thank you very much.
Our next panelist is Professor Dr. Astrid Stadler. Astrid holds a chair of private law, civil procedure, private international law, and comparative law at the University of Constance in Germany. Her fields of research are civil procedure law with a focus on collective redress. She is vice president of the German Association of Civil Procedural Law. She has published more than 60 articles on collective redress. Astrid will talk about the EU Commission's proposal for a new deal for consumers. Thank you, Astrid.
Well, it's a great pleasure and privilege to be part of this conference, and as we have only a very small time slot, I will simply jump into my presentation. What I would like to do is to address two recent developments in Europe. Both are still only projects. One is, as you can see, Ariel has already mentioned that, the proposal of the European Commission, published in April 2018. And the other project I would like to address is a soft law project launched by the European Law Institute and UNITRA some years ago, which also includes model rules for collective redress. Well, you may know that in 2013 there was a recommendation by the EU Commission, but it was only a recommendation. It was not a binding instrument, and not many member states have really followed that recommendation. Nevertheless, there is a lot of reform ongoing in Europe, and we now have a more or less very heterogeneous landscape of collective redress in Europe. The EU Commission published a very comprehensive study last year, which gives you all the details of the reform if you're interested, and the most important reforms will be addressed in future presentations, particularly the UK and the Netherlands, which have adopted a new collective redress action only a week ago. So the EU Commission proposed a very comprehensive package of instruments, and this includes a proposal for a directive of representative actions for the protection of the collective interest of consumers. On the other side, what I would like to compare to this proposal is the ELI and UNITRA project. It is, so to say, a follow-on project which builds on a project completed in 2004, a project, a joint project of the American Law Institute and UNITRA about transnational principles of civil procedure. The new project now is a bit more ambitious because the idea is to have a complete set of rules on civil procedure law, and this includes a chapter on collective redress, and I had the privilege to be part of this working group together with some other people who are present here. And well, it's still work in progress. The drafts will probably be adopted by the European Law Institute in September this year and by UNITRA in May of the next year. Well, if we look at these two projects and compare some of the key issues, if we look, for example, at the scope of application, you will realize that the scope of application of the EU proposal is quite limited because it refers only to consumer law. The reason for that is that, sorry, okay, I try not to move too much. The reason why the EU Commission has restricted the scope of application is that they have a limited competence for binding instruments, and they are safe if they do it for consumer law, but they have probably no jurisdiction to do it for the harmonization of regular civil procedure law. The ELI project is much broader in its approach. We adopted what the EU recommendation in 2013 had in mind, a broad horizontal approach with no restriction, of course. That's much easier for model rules than for a political project like the EU Commission's injunctions. If we look at the main instruments of both projects, the EU Commission starts by the idea that they will build their new proposal on an old direction we have had since 2002. That was about representative actions only for injunctions, for injunctive relief, and now the idea is to supplement that by a new instrument for representative actions for damages or other forms of redress. However, as you will certainly know, class actions, collective redress is a very controversial issue in the EU. There are some exceptions in the proposal. For example, member states should be allowed to implement only an instrument for declaratory relief, where, as the proposal says, due to the characteristics of the individual harm concerned, the quantification of individual redress is complex, then only an instrument for declaratory relief is allowed, but there is, so to say, a counter exception. There needs to be a representative action for damages whenever the consumers concerned by the infringement are identifiable and suffered comparable harm. And if you look at the press releases made by the European Commission, they have in mind that, for example, the Volkswagen case will be a case for this counter exception. So for the Volkswagen case, member states should be obliged to implement an instrument for damages. There are special provisions for the case that consumers have only suffered small individual loss, and in this regard, the Commission proposes an opt-out instrument. And for the first time, they have now adopted the approach that there should be no compensation for the consumers. If it's too difficult to distribute the amount of money to a lot of people, then the redress is to be directed to a public purpose, serving the collective interest of consumers. So this is what we know from the US and from the UK as so-called Cypress solutions. And there is also an instrument adopted from the Dutch system. It is a standalone proceeding for declaring settlements binding, which have been negotiated outside court proceedings. On the other side, in the ELI and UNITRA project, we have similar but maybe more straightforward instruments. The main instrument of the chapter on collective redress is an action for recovery of damages and all other forms of redress. We have some detailed rules for a mechanism to declare binding settlements which have been negotiated during a pending action, but also a standalone proceeding to declare binding collective mass settlements negotiated or entered into outside collective action. There's a trend to have these instruments The Dutch were the first to implement that in 2005, and now we have similar instruments in the UK and in other member states. Injunctions are not part of the collective redress part, but of course they are allowed. There are several reasons to treat them separately. I will not go into that now. Well, some key issues were, of course, one of them legal standing, and we have already heard from Ariel that the approach of the EU Commission, again, is very narrow. Only qualified entities established under the member states' law will be allowed to bring these actions, and it has to be a non-profit-making organization, which has a legitimate interest in consumer law, but member states have also the option to give legal standing to public regulators or administrative authorities. Again, the approach of the ELI UNITRA project is a bit broader and closer to the EU recommendation of 2013. According to the chapter on collective redress, it's not only organizations and representative entities, but also ad hoc established entities which represent the interest of consumers for a particular mass harm event, and also individual group members and consumers should have legal standing. Another very controversial issue we've been discussing all over the last 10 or 20 years is how to identify the group or class, whether it should be an opt-in or an opt-out mechanism. The EU Commission's proposal now leaves it to the member states to decide whether it should be opt-in or opt-out, and only for the cases where we have very small individual loss, the proposal says it has to be opt-out. In the ELI UNITRA project, we start from the basic idea that it should be an opt-in mechanism, but the project and the rules give broad discretion to the courts to decide on a case-by-case decision whether it should be an opt-in mechanism. If they have the feeling that not many group members will opt in, then they can choose to apply the opt-out mechanism, and that provides a lot of flexibility. Maybe today the most important issue is financing and funding of mass litigation. We will not find a lot of rules in both projects. The EU Commission's proposal only says we have to stick to the loser pays principle. Third-party funding is not explicitly prohibited in the proposal, but if you read it, you can find that there are a lot of restrictions, and the Commission is obviously not very enthusiastic about third-party funding. They have some restrictions, for example, that third-party funders should never have any influence on the litigation, that there should be some transparency, and the basic idea of the EU Commission is that it is up to the member states to give financial support to the qualified entities, which is, of course, something we have to wait and see whether it's going to happen. Also in the ELI and UNITRA project, there is not much about funding. We also start with the loser pays principle, and there are some rules which explicitly permit third-party funding. There is a kind of transparency. We say it's necessary to identify whether there is a third-party funder and who it is, but of course the third-party funding agreements should not be made public and should not be given to the defendant in particular. What is not in the rules, but only in the comments of the ELI project, is the idea that member states should really consider to establish access to justice funds, because this is probably one way to finance at least particularly consumer mass litigation, because third-party funders are often only interested in the big mass harm events and not in consumer cases. So I come to my last slide. A very, very big issue, of course, that we have to deal with thanks to the big bad wolf in the United States is safeguards. It has been a main argument of the business sector that whatever instrument of collective redress we will implement, it will be, there will be misuse, there will be a litigation industry, and you all know the arguments. That was the main reason why the EU Commission also said legal standing should be given only to non-profit making entities. And another reason, number two, is that the courts have to have a two-step procedure, and in the first step they have to decide and they have to give a declaratory judgment, and only in the second step claimants can ask for damages. So, of course, this is to prevent unmeritorious and frivolous claims. What is more or less self-evident that the claimants must have sufficient financial resources in order to meet adverse cost orders, but also to protect the interest of the group members. And I've already mentioned third-party funding. And of course, a main instrument, main safeguard is that settlements need court approval. On the other side, I will not go into all the details, but you can see that we have a lot of safeguards put in place in the ELI and UNITRA project. I would like to highlight only two of them. If you look at number 2 in the ELI project, it's not the representative entity which has filed the representative action, which is going to be the representative during the litigation. At least that is not that is no guarantee, because the court has to do something like a beauty contest and give the chance to other representative entities which may have also been preparing a collective redress for the same Marshalm event, and at the end of the day it is up to the court to select the most qualified entity and qualified claimant. And another safeguard we have put in place is number 6, that in order to prevent a race to the courthouse, each qualified claimant must make an attempt to settle the case before filing a collective action for damages, and must give the defendant at least 3 months to react to that. So I'm at the end of my presentation. As you see, both projects are still dreams for the future. It's difficult to predict what's going to happen. We will have a new EU Commission by the end of this year, and we have to wait and see whether the new Commission will also pursue this proposal. There's probably no chance that it will be adopted within the term in office of the current EU Commission. And of course, the ELI project, it is only model rules. There is no binding instrument behind that, but probably, or maybe they have the chance, once we have an instrument at the European level and member states have to think about how to implement these instruments, they may have a look at our model rules, and maybe that way they may become successful. Thank you much for your attention.
Professor Albert Ruda is next. He's an associate professor in private law and dean at the Faculty of Law of the University of Girona. He is a member of the Institute of European and Comparative Private Law and a member of the European Center for Tort and Insurance Law. He is a researcher, a research fellow of the Utrecht Center for Accountability and Liability Law. Albert would like to talk about class actions related to privacy and personal data breaches. Thank you, Albert.
Thank you so much, Mr. Chairman. Please let me start by thanking the organizers of this conference. I'm very glad to be here, my first time in Israel and in this important event. I just wanted to tell the organizers that I'm not aware, probably you're not aware that the conference already started in Spain before I got into the plane. I had to explain the security staff in Barcelona airport what the conference was about. They even asked me about class actions, you know, what I was going to do here. And they always wanted further explanations about class actions. It was very interesting to start the conference already in Barcelona. So I'm going to focus on collective redress and class actions, mostly in Spain. Ariel was so kind as to ask me to talk a little bit about Spanish law, so connected to a global perspective, some other European developments. So I'm going to introduce a Spanish note with some international connections as well. As you may already be familiar, big data is the new oil, the new society of the information and communication. There's lots of data, big amounts of data, and this big data allows companies to profile us, to create profiles of who we are, what we like, what could be of interest for us, so we can get personalized offers, the products or services which potentially interest us. This has many advantages. Of course, this could be time-saving. We can go directly to those products and services we like, but of course, it doesn't escape you that it has also many risks. What happens if this big data is misused, if the companies who have all this data in their possession start using it in a bad way. This is a classical scenario for class actions and collective redress. There is a potential large number of people affected, potentially millions of users in the internet, for instance, could be affected by these violations. The harms, the kind of harm suffered by each of these persons is very small if we consider it on an individual basis. But if we aggregate the harms, of course, this is from a potential perspective, it's a very large harm. Damage suffered by every individual is very similar. I mean, for instance, if we take Facebook or Twitter or these social media platforms, the kind of damage that users may suffer is very similar. So there are good reasons to treat these claims together if potentially a claim is filed on the basis of procedural economy to save time and to save money, and also for the sake of internal consistency of the system, just to avoid contradicting decisions by the courts. So I'm going to present now two collective actions that have been filed in Spain. I will make reference, just a very short reference to the first one. The first one was filed by FACUA, and I will concentrate on the second one filed by OCU. FACUA is one of the most important consumer organizations in Spain. It has recently filed a complaint before the public administration in Spain. We have a data protection agency located in Madrid, and this agency has administrative powers, so it can, for instance, impose fines on companies which infringe data protection rules. And this is what it's about. It's an administrative complaint, so now the Spanish agency may decide on whether Facebook and other giants in the area of big data and social platforms may have infringed the Spanish law. But this agency cannot award compensation awards to consumers or to claimants. I mean, this is just about the administrative or the public law aspect of it. So I'm going to concentrate on the second claim, which is, properly speaking, a court claim, a judicial claim. It was filed by OCU. OCU is another big player in the field of consumer protection. It was established in 1975. It's a private law association with more than 300,000 members. The triggering event of this claim filed before the courts in Madrid was the Cambridge Analytica scandal. As you may already know, there was a mobile app which every Facebook user could connect to its Facebook account, and apparently this app misused. It had access to the user's data and also to the data of third parties, third people who were connections, who were friends in Facebook. And this data, all this data, the users and third people data was used for the purpose of political profiling, and therefore also in recent elections. This is the trigger, as I mentioned, but there are also other scandals and other problems which are commented upon by the claim. Apparently, OCU doesn't just focus on the Cambridge Analytica scandal. What they say is that the problem is the whole business model which is run by Facebook. So they have filed this claim where Facebook is the defendant in order to change the way that Facebook does its business. I have to say that the claim is not yet public. I've tried to get access to the claim. I contacted OCU. They were very reluctant to say much about the claim. I expected that I would be able to share more information with you, but they didn't want to. You know, the claim has been drafted by a law firm in Madrid, but they didn't want to show the text just in case. So what does OCU say that was wrong with Facebook, or what is wrong according to OCU? They complain that that Facebook, didn't request the consent of the users of the platform to use their data. Facebook didn't inform users about this use. They also talk about a property violation. They present it as violation of property on data, which I think raises a very important question, because it's at least from a Spanish perspective, and I think that also from the perspective of many other European legal systems, it's not that clear that there is anything like property on data. They also stress the fundamental right aspect of this issue, that the fundamental right to personal data protection has been infringed. And they also make reference to the diffuse character or nature of the claim. They talk about intereses colectivos difusos. They use this expression constantly in press releases. When they publicize, they talk about the claim, which I find a very confusing expression, but anyway, it's how it is. So what is OCU claiming? They are claiming that certain standard terms, in the general terms, in the terms of use, which you may have already have a look at, are void, and they are declared void by the court. They also request the court to paralyze the activity, so stop misusing personal data without consent, and also abstention or refraining from doing it in the future. And most importantly, they claim compensation. They claim compensation for every single Facebook user in Spain. And it's very interesting to focus on the compensation award that they are requesting. They are requesting €200 per person. I'm not sure why €200. This is one of the aspects which is not clear from my perspective if we compare it to other similar claims which have been filed in other countries, in the US, in the UK, or in Austria. The figures vary, so it's not clear to me how they establish, how they determine this amount. But in any case, if they succeeded, that would mean a compensation award for more than €5,000 million. So probably the most important tort law case in Spain ever. The claim was filed last October, so it's a very recent event. It was filed before the Madrid courts. We have a separate commercial court in Madrid. The claim is, so to say, sister to other claims which have been filed in other countries, in France, in Italy, and in other places. Potentially there are 26 million potentially affected people, which this is the number of Facebook users in Spain. And the compensate, according to the press releases, is the purpose of the claim is to compensate all users who could be the victims of data bad use. If we take into account the number of users or of people affected by the Cambridge Analytica scandal in Spain, it was just 137 users, according to Facebook, so it's larger than that. It potentially affects millions of people in Spain. So OCU launched this campaign, which you can see on the slide, with an invitation to join it. So now people are registering. I checked yesterday evening, it was 490 users. This morning, 3 more people registered, so people are registering all the time. Maybe as I am speaking, there are other people joining the claim. And yeah, they started this public campaign under the catch expression, apoya nuestra acción, support our action, without explaining much, without explaining what support means. Does it mean that you are joining the claim? Does it mean that they are going to inform you? They don't explain much. So as I said, this claim is connected to a manifesto which was signed by several European consumer organizations. You have the names in the slide, and they always insist in this ownership idea that data belongs to the user. So the basis of the claim is basically privacy, data protection, the fundamental right to data protection, users' autonomy. The users weren't asked to give their consent, and this data ownership, they claim that mis datos son míos, my data are mine, you know, so they insist on this idea. Facebook hasn't said much about that. If we have a look at the press releases, they simply deny, they say that there is no problem whatsoever. There are similar claims in other countries, as you may already know, similar claims, connected claims, claims in similar scenarios, data protection, geolocation tracking, access to private data, access to SMS, to conversations, many other claims against Facebook in other places as well. So, and I'm coming to the end now, the general framework under Spanish law in which this claim will have to be decided is far from clear. Legislation is an example of unclear drafting. It has been repeatedly criticized by Spanish scholars like Teresa Armenta, many other important scholars, also scholars from my university. So we probably need a redrafting, a revision of legislation. And since this is a major case, this may be a good opportunity to reflect on what happens and see how this claim develops. The claim has been apparently filed under Article 11, which is not a model of clarity. We don't actually have class actions. We have collective actions. And so no single citizen can file a class action, but consumer associations can, as I explained before. So what's next? Now, probably in the following weeks, the Madrid court will have to decide whether the claim is declared admissible or not. There may be probably a call for individual Facebook users to join the claim. And there will have to be proof of damage. The OCU organization will have to establish what the damage consisted of, which is not clear from my perspective. But we can talk about that maybe in the debate. And this experience may be also useful for a potential future revision of Spanish legislation. So thank you very much for your attention.
Our next guest is Professor Janika Tsankova. Hi, Janika. She's internationally recognized for her knowledge of strategies for resolving trans-border mass disputes. She's an academic program director at Tilburg University. Janika is consulted for expert opinions on Dutch civil procedures, product liability issues, securities litigation, cartel damages claims, and issues related to class and group actions, and regularly lectures and publishes on those topics. Janika is going to talk on the Dutch new collective damages actions bill.
Thank you. Good morning, everyone. First of all, thank you for the organizers of this wonderful event for your hospitality, including graciously arranging the delay this morning. Gave us opportunity to catch up with some old friends and make new ones, so no complaints on my behalf. Indeed, I was asked to give you an overview of the Dutch developments. And before I do that, let me tell you why I think you should pay attention to what's going on in Holland. At least 3 reasons, I think. Firstly, the Netherlands has, not many people know that, for 25 years, a very active, comparative, certainly to what's going on in other jurisdictions, collective action practice. This year, the 305A statute would have existed for 25 years, and that has resulted in over 350, for sure, collective rulings by the lower and higher courts. Secondly, the Netherlands has this interesting combination of European features of collective redress and American features. The European features, the 305A actions, the typical European collective redress approach, the standing granted to non-profit foundations or associations. We have no punitive damages, no contingency fees. And on the other hand, we have the WCAM, this instrument that is inspired by the US settlement-only clauses that allows for courts to approve collective settlements on opt-out basis. And we have, unlike most other European jurisdictions, the option to set up on ad hoc basis special purpose vehicles. And not always, but often they are being backed by commercial initiatives. So we have this interesting mix of the European features of collective redress and the US, and this all brings a wealth of rich experience of what can go well and what can go less well, and teach us about the issues that other jurisdictions might come across that now they're starting to introduce their own collective redress devices. So when we speak of Dutch collective redress, what are we talking about? We are talking about assignment of claims model. In Germany, it's being disputed. In the Netherlands, it seems to be working well so far, and it's widely used, interestingly, mostly in the cartel damages claims. We have the contractual claim assignments, the aggregation of claims, that is the typical traditional methods. And I am sharing that with you because you might think, well, if you have a 305A action or if you have collective action and settlements, why would you use these? But indeed, we do use them, and they're very much used in the area also of consumer claims. Then we have, as already mentioned, the 305A statute that allows only for injunction and declaratory relief. Has a horizontal approach. That's another interesting feature. So no limitations to any substantive area of law. You could use it horizontally across many practice areas. And we have I already mentioned the Dutch Act on Collective Settlements, and since last week, and Ariel I think already pointed out to it, the Dutch Senate approved the new proposal that will allow for Dutch collective damages actions. We don't know yet when it is going to be enacted. That is still in discussion, on negotiations. But we do know that once it gets enacted, it will apply only on wrongdoings that took place after the 15th of November 2016. I don't know whose birthday that was. I don't know why this date was picked, but that is what we need to encounter. So it will mean that for an unclear period of time, we will be confronted with parallel regimes, the four that I just mentioned, plus the new collective damages action. So what are the main features of the new proposal? If I have to say in 2 words, very much in a direction of US certification, for those of you who know what it means. The standing is still the European style. It's still exclusively attributed to non-profit foundations and associations, but also ad hoc established ones. But they need to go through a lot of requirements to get this certification in place. They need to demonstrate that they have a perfect governance. I will not go into that, what it means, but a lot of board members, supervisory board members, and all kind of other requirements that the foundation needs to meet, or the organization putting this forward. And there is going to be an exclusive representative. So I understand that some of my US colleagues don't like the word beauty contest, so I will not use it, nor adverse selection. That's another bad term. But there will be a selection by the courts of potential candidates among those organizations who come forward, and one will be appointed as exclusive one and the other ones will be stayed. Another feature, US feature of the proposal, Ariel mentioned it already as well, is the opt-out feature. So it will be, once it's certified, then potential class members will get opportunity to opt out. After some criticism, this has been limited to only Dutch domiciled class members, so the foreign class members will need to opt in. But even then we have an exception if the organizations argue the case properly, then the court still might decide to include also known foreign members under the opt-out scheme. So another extra requirement that has been introduced, and that is somehow questionable. Astor and I have been discussing this the past year. The so-called scope rule. The scope rule requires the action to have a specific nexus to the Netherlands legal sphere. There are also all kinds of requirements that can be tested with respect to that. A majority of individuals could be situated in the Netherlands. From European private international law point of view, this is questionable because one may wonder whether this isn't an extra requirement outside of Brussels I regulations. We've been told when we shared our concerns with the Dutch Ministry of Justice that this is something different. This is simply limiting the material scope, and that is national law. And as we all know in Europe, national law is something for the national legislatures. I am a bit skeptical. It could have been a window dressing to get this proposal passed by the business lobby. We'll see. That is a big question mark, how that will play out. So this is, as I said, a true certification, as we know in the United States. Funding will be an issue, in a sense that the organizations that would be able to come forward and to demonstrate that they meet all these requirements will need to have deep pockets. I guess that is good news for the third-party funding industry. But then that would mean that the transaction costs of those actions will increase. So it is a question mark to me as well whether our proposed system is more efficient than the one there is in the United States, for example. Another final remark I want to share with you is that because of the criticism of, that came out from academics, some of my colleagues, including myself, on this proposal, one of the main criticisms was that it increases also the bar for public interest litigation, because that would require, the proposal would require for all the non-profit, truly non-profit entities that are limited in their resources to also go through this very cumbersome and extensive certification process. So there has been an amendment that such organizations could actually apply for an exception from the heavy requirements. Final comment on the cost and financing part. Again, last-minute amendment. It has literally happened like in the last 2 weeks before the final voting in Parliament. There is again this fear for the big wolf from the United States and so-called frivolous actions. So in order to address that concern again, a cost rule, special cost rule has been introduced that the claimant organization could be fined. We don't have punitive action, punitive damages, but could be fined 5 times the typical liquidated costs according to our system. So that is in a nutshell what's going on in the Netherlands, and I am sure we'll hear much more about it in the future. And I'm realizing I'm saying that my last remark, but now I will really make my last remark because I think it's important, and that is that also under the new proposal there will be a collective settlement regime. Interestingly enough, that's a different one than the WCAM. And I will leave it here. Thank you.
Professor Claudia Lima was introduced by my colleague in the previous panel, so please. Sure.
Thank you very much. First of all, I want to thank this opportunity. I'm a professor for private international law. So, I'm a lawyer also, and I used to be president of the Brazilian Institute for Policy and Consumer Law, Brasilcom. I thank Dr. Professor Rosângela Cavalazzi that gave me this very beautiful PowerPoint presentation from Brasilcom. And in this position, I used to act as a pro bono lawyer, as amicus curiae. This institute, non-profit organization, is amicus curiae for a lot of class action and also new instruments for collective redress that are like model actions in Brazil. So I changed my speech from global cooperation that I think we should build for these new developments in the Brazilian jurisdiction. We are 200 million persons in Brazil, living in Brazil with a lot of damage, and the civil society also is waking, and so we have a lot of claims. And then perhaps this collective redress should be hitting. This is my point. So I will begin. Right, what do you use this? Just this. Thank you. The first point is the rising numbers of claims in Brazil. You can see 93.5 million, now 29.1 million claims. It's a lot. And also, I put some information, I think you can see. Settlement is conciliation is very low at the moment. Each judge has almost 1,800 cases each year. This is a lot. The pressure we have a very great litigation. And the timing of these sentences, the first sentence and a lot of remedies that we have is really long. So the positive idea of Brazilian class action, really the name is public civil action. It's not really a class action. Individuals cannot claim directly. But I put that we have old statute for 85 that give this possibility to make this class action, a Brazilian class action or collective redress. And but the consumer code from the 90s has complete this idea and focus on consumer protection. From now on, I will focus only on consumer protection. That is the field that I work. Some key issues of this idea, the standing, locus standing is a mix between now the European ideas and the North American ideas, and also a very positive way to go is this has judicata in favor. If the sentence is in favor to consumers, so there will be erga omnes. And the problem with the enforcement, they solve, I used to work at the Minister for Justice when they make this law, and then there are some colleagues that come from the US and the other from European and also from Mexico. So they try to make a mix, and then they develop 2 levels or 2 degrees. And the first sentence, all the public prosecutors, defenders, or associations or agencies fight for the consumers, but in the second more enforcement place or executive action, the consumer can make an opt-in in this moment, and if not, we have a general fund that will give the redress indirectly for consumers through the society. So the positive impact, I give two examples. We have some data that perhaps interest in you. We should have a register, a national register for all Brazilian class actions, but it's not working. It's for 2014, but they have some interesting figures about agreements and recommendations. So perhaps I go one step before and say that this new system that they created with the Consumer Protection Code from the 90s give a lot of power for the state through public prosecutors. They have one inquiry, so it's an investigative tool. And they do this very, very in a solid way, very good. And so the most cases, they make only recommendations to, like an injunction, to preventive action, to not to do anymore, to refrain what they do bad. And the second level, they make collective statements, and they can be a fine in this stage. And here you have some data about the year. And we have two kinds of public prosecutors, federal with state's case, and each state. I chose São Paulo because it's the biggest one and more important, so they have more cases. Normally, the Brazilian collective claims are made by them. And then I give an example of a claim that is going on. This is in my state. It's like the diesel gate, but it's a national case. An importer of products that they say this will reduce the environmental pollution and also reduce the use of the gas. And it was everything false. And this is a case that began in 2011. They make this investigative tool with a lot of evidence, data, statistics. They work very hard, and they have means to pay this, also because this funds. And then in 2018, we have a very good sentence, damage, individual damage, a refrain, and the fundamental of the decision is the advertise that was false, misleading, and also collective damage for the society, because with this advertise, they elude a lot of people during a time frame. So very, very good decision, but a lot of years later. No? So what my point, this setback that we can see now, with a law for 2008 to reform our civil procedure code, they introduce a new collective redress system, and this will be consolidated in our new civil procedure code for 2015. So some ideas about this new procedure. Sorry, I cannot see in this, but anyway, the critic is that they are in this new civil procedure code. There were an article to convert individual cases to collective cases, do an ex officio or claim from the court, or for the public attorneys and also the public defenders. The state could convert. This article was, they gave a veto to this, but the other article remained. That means that the courts, the Supreme Courts in all the states, Brazil is a federation, and also the Supreme Court in Brasilia, can choose ex officio some cases that are repeated or repetitive, and with the same law questions, and make a new collective redress. The requirements are two: the real recurrence of judicial proceedings that comprise the same questions on a point exclusively of law, and B, the risk of an offense to the equal treatment under the law and to legal security that may arise from the same question of law being decided differently by different courts in Brazil. So they created this incidental procedure for resolution of repetitive cases. The idea, it was the Musterverfahren from Germany, but they use it in capital cases and not, I'm not sure, in consumer cases. And so what are the problem with this? And then I'm aiding. This is an abstract legal thesis that has a fast track, and then will be binding for also for collective class actions that stay there and need years to be made by the associations or by public procedures. They have statistics, they have all the evidence in this collective class, but of course not in an individual case. Sometimes we from the Brasilcom must act as a lawyer, pro bono lawyer for these people, because they don't know even that they are choose to be in the Supreme Court very quick. And of course, also the consumer amicus curiae are now we are a little lost, because we must to have a lawyer only to follow these repetitive cases. Are more than 90 in the moment in the Supreme Court, civil Supreme Court. The lobby of the professionals of the Federation of the Professions are very happy. They all are amicus curiae, there's 6 or 10 amicus curiae in one side, and 1 or maximum 2 amicus curiae in the other side. We are everywhere there. But, okay, thank you. And of course, the agencies, the regulatory agencies in Brazil, seems to be always in the side of the capital, of the providers. And the economic argument of the system, that is not an individual case, but a million of cases that are stopped when this proceeding, incidental proceeding, is decided by a Supreme Court. For example, all the others in all the courts are stopped. That make a lot of judges very happy. And the problem is that we don't solve. We had 2 bills to solve this problem of priority. What should be priority? In the Consumer Code, they say that a collective Brazilian class action should be has the priority, but the bill that will reform the Consumer Code has not passed. The other 2 bills in the more other subjects has half sanctioned by the Senate, but this bill was dropped. And also a former bill that gives precedence for class action. So we see a very negative impact in this jurisprudence, also consolidated precedents in favor of consumer. Now they are going down. And also 2 new developments that we don't have collective arbitration. We have collective conciliation or mediation for, but with the states for big accidents. And so in the individual cases, there are no precedents. So we are trying to use this as a binding form. Also, some platforms of the government that should be voluntary. Now, some judges are used as a binding to avoid so many disputes in consumer cases. So my conclusion, sometimes less is more. We spoke here about a romantic era of class action. I think we should go back to this romantic area and try to develop a very interesting and good for all, also for emergent countries, useful instrument for collective redress. And about new trends is the global challenges. The same cases are in all countries of the world, and so perhaps these model laws or more cooperation should have priority. In Latin America, we try with a model law, but unfortunately it was not successful. So let's try again with UNIDROIT and other instruments. And about the only good news that we have is in the UNCTAD, in the UN, they created an intergovernmental group of experts that has not yet focused on enforcement, but and also collective redress. But perhaps we should suggest this also for the emergent countries in the world. Thank you very much.
Last but not least, Miguel Sosa Ferro. He is a professor at the University of Lisbon Law School and at the European University in Lisbon. He lectures in the fields of competition law, EU law, and economic law. He is a practicing lawyer with extensive experience in competition litigation. He has over 80 papers and 5 monographs, including the recently published the EU Antitrust Damages Directive. Miguel intends to describe the current situation of collective redress for antitrust damages in the European Union. Thank you, Miguel.
All right, thank you so much. Yeah, last and let's face it, probably least, at least in terms of my age, and I'm very, very humbled to be here. It is such an honor to be speaking in front of all of you, and it's a great privilege to be able to do a presentation where I know I can just go deep into the details and skip over the generic stuff. I'm doing a tough balancing act here with this large computer on this very small frame. I come from Portugal, and if the USA is the big bad wolf, Portugal, in terms of its class action law, is surely the sheep in hippie clothing, and I'm very proud of that. I think if they are the cautionary tale, we're the Prozac pill, telling people to chill. It's fine. Our laws, as you know, are incredibly flexible. We have a single consumer can start an action representing everybody. We don't have rules on class certification. What is that? We don't really have rules on controlling funding, or we don't have to have minimum deep pockets or anything like that. It's amazing. You don't pay initial costs. At the end, you barely pay any costs, even if you lose. So it really is a paradise, which is why it's amazing that nobody uses it. In fact, I had a German professor who said, "Yeah, you have it because you don't use it. Because if you used it, you wouldn't have it." And he's probably right. So I come into this topic with this frame of mind of somebody who is I find it's very alien to me, the whole thing of the fear of abuse, because I live in a country that put together with the other characteristics of our legal system, especially in terms of costs and legal culture, for us this fear really does not exist. But I would like to address today the reality in antitrust across Europe. And I think that antitrust is a great litmus test for the health of collective redress in Europe because, especially now after the damages directive, it is so easy to win an action. I mean, obviously it's not. But, I mean, we have the infringement. The infringement is proven. If it's a cartel case, you presume that there are damages. You just have to quantify them. And even quantification, if it's too difficult, the court just has to estimate it. So it should really be very simple. And it's in light of this framework of incredible simplicity and accessibility, specifically in the framework of antitrust, where you have so many decisions every year by competition authorities, European Commission, but also national competition authorities. So many decisions which basically everything is already prepared. Consumer associations or consumers or other litigants could just take that and go to court and ask for compensation. So in light of this, I think it is a good litmus test for us to assess the health of collective redress systems in Europe. And of course, most of you in the room already know what that health is. It is the health of a decrepit, middle-aged man who doesn't really like to go out of the house, essentially. It's inexistent. And I think this is the most important point that we can make in the discussions about the fear of collective redress. There has never, ever been a successful collective redress action in antitrust in Europe. Ever. I mean, of course, I'll get to the exception, but the exception is not a real exception. This means that throughout decades of decisions of saying that consumers were effectively harmed by antitrust practices, never have consumers been compensated for these practices. And as an academic, I look at our governments, the governments across the EU member states, and I have to ask, how are you okay with this? How is it possible that you can live in a legal system where systematically consumers do not get compensated, and at most companies have to pay a fine, which economic studies have more than shown are not sufficient dissuasion? So what is the situation across the member states in practice? Well, in the UK, as you know, we've had a few attempts at class actions. The football shirts, somebody already mentioned the football shirts case. Famously in that case, at the end, there was a settlement, so it looked like a success, but it's the success that proves how failure can hide in success clothing. Only 144 were compensated out of an estimated 2 million possible injured parties, if I have the figures right. So that's not a success in my book. Then you had the mobility scooters case, which was thrown out, basically because of a restrictive approach by the Competition Appeal Tribunal, which led the applicant to say, well, if we have to do all that, then there's no point. We're not going to be successful. It's not worth it. We're not going to get our money back. And they ended up having to pay the other party's costs. So, not a good lesson for future applicants. Then you had the MasterCard case, which was even worse. In MasterCard, the Competition Appeal Tribunal basically said, mass consumer claims? No, forget it. That is basically the lesson of MasterCard. Of course, it's still being appealed, but please, somebody disagree with me and convince me otherwise. But what I read in MasterCard is that unless you can, right from the start, put forward a methodology that will clearly show how you will quantify the damages for each injured party, each consumer, and how to distribute them, the court will not accept the action. Which, of course, means that you cannot have mass consumer damages actions unless the damage is incredibly simple and homogeneous, which will almost never be the case. In the EU, as you've already heard today, we're moving past this way of thinking. We're already, at least at the legislative level, we're trying to persuade national legislators to introduce a system where even if you cannot accurately redistribute, the most important thing is take the money away from the infringers. By God, let us not let the people who committed the infraction of competition law or other laws keep the money just because it is difficult to decide how to distribute it. We can calculate the damages globally, so let's do that, and let's use the money for the welfare of society and the justice system, and instead of keeping it in the hands of the people who broke the law. So let's hope that that moves forward. In other jurisdictions, France, you had the UFC que choisir case, which was also a failure for procedural grounds. In Spain, you had the Ausbank versus Telefonica case, a failure on procedural grounds. In the Netherlands, I'm not really aware of, well, of course, with the settlement proceedings, it would be different, but I'm not really aware of cases that were successful, but maybe you can elucidate us. In Portugal, we have one pending case in which I'm an interested party because I'm representing the applicant. It's an association of academics that did a follow-on action. When we had to go to a generalist court, we're representing at least 500,000 consumers against a sports channel. And we said, here's the decision, please give the consumers the compensation. And the court was incredibly scared, never heard of competition law in their life. 500,000 consumers, millions and millions in damages, and they came up with every possible obstacle not to decide the case. Finally, they threw it out on grounds of legitimacy, even knowing that it was going to come back. We went to the appeal court. The appeal court said, yes, you do have legitimacy. Now we're waiting for it to go down. In the meantime, 4 years have gone by, and the case hasn't started. So it's not exactly, sure, we're hippies. Things go slowly and calmly, and sooner or later we'll get there. But because I'm running out of time, I would like to talk about some of the issues which I think are, well, I won't cover some of the ones that have already been mentioned, but I would like to address some of the topics that concern me the most. One, economic viability, for me, is the key issue right now in collective redress. The possibility of the promoter recouping costs is not obvious in every member state. It depends on the national rules. For example, in Portugal, it was not guaranteed until recently that we could recoup the cost because we don't have the loser pays principle effectively. The possibility of limiting the promoter's responsibility to pay costs is also very important. If you want consumer associations to promote these actions, you can't at the end say, and now you have to pay the litigation costs and the economists of the other side because you lost the case. That's just not reasonable. No consumer association is going to take that chance because they would end up having to pay millions of euros, especially in jurisdictions like the UK or the Netherlands or Germany. And also, as we've heard today, if you require deep pockets, that is also basically killing these actions. Nobody's going to be able to prove that they have the financial capacity to fund these actions if they lose and they have to pay millions and millions of euros. The people who will be able to prove this are the litigation funders, and litigation funders have to get something back for their investment, and it's not obvious what they can get back. In Portugal, they can't get anything back. So litigation funders aren't interested in class actions in Portugal, obviously. The other issue I would like to bring up is multi-jurisdictional collective redress. This is a particular concern of mine because it hasn't yet been tested whether, for example, the Portuguese opt-out or the British opt-out or the Dutch opt-out, which is coming, will be able to be used to represent people across the European Union. As we've heard, the proposals are going in the opposite sense, saying opt-out only for nationals or residents and opt-in for everyone else. I don't understand that because it is just as easy to publish something in a newspaper in the Netherlands as it is to publish it in Portugal. I don't find a reasonable justification for this limitation. I don't understand how in the European Union we can accept that consumers have to file 28 different actions in the member states in order to get compensated and relitigate it 28 times and be taking the risk of different outcomes and different quantifications. I don't understand that. I also think it infringes the principle of non-discrimination according to nationality, maybe also the principle of equivalence, but certainly the principle of non-discrimination. Why wouldn't a consumer from another member state be treated exactly the same as a consumer from your member state? You need a justification for that, and difficulty to notify them is not a reasonable justification in my book. And finally, the last step I would like to mention, because I'm out of time, is public-private enforcement. We're, unlike the US, we're a very public sphere-oriented continent. Until recently, antitrust was mostly administrative, public enforcement. And I think the solution for consumers really is, in Europe, I'm not saying this would work for other areas of the world, but in Europe, it seems to me that the best solution would be to move towards regulatory pushed regulation, independent regulators pushing for private damages. It can be in several ways. It can be them themselves imposing damages and then companies can appeal, or them having a right of initiative at the courts to start an action for damages, or together with the public prosecutors. There are many models that we can try, but I think that this is a philosophical change that should happen in Europe. Why should our states be more concerned with imposing fines than with compensating victims? I don't understand that. If we believe that compensation, that antitrust in other areas are so complicated that they require specialized knowledge in order to be able to apply them by independent regulators, then you need specialized knowledge in order to be able to apply them in the private sphere as well. What is more important, compensating consumers or getting companies to pay a fine which we know will not be sufficiently dissuasive? Thank you very much.
I guess you need some coffee at this moment, so we have a 10-minute coffee break. Thank you.